Good morning, everyone, or good afternoon, as the case may be. Greetings from Vancouver, British Columbia. My name is Joe Weiler. I'm a professor emeritus at the Peter A. Allard School of Law at the University of British Columbia. And I'm co-director with my friend and colleague, John Ritchie, of the Anti-Corruption Law Program. Our program is a joint working partnership in continuing professional education. And the partners are the Center for Business Law at Allard, Transparency International Canada, where I have the privilege of being co-chair, or vice-chair, sorry, and the International Center for Criminal Law Reform, ICLR. This is the 28th seminar or conference of the Anti-Corruption Law Program in our 5 years of operation, and it's the 8th of 9 in 2021. And it's an example of how three leading organizations with different core competencies, but a common mission of fighting corruption can take collective action to work together to provide continuing professional education services to our community. And we do this by bringing together the leading experts in the anti-corruption field to teach each other about the best ways of fighting corruption and promoting integrity in our society. I want to give special thanks to Dr. Carol Liao, who's the director of the Center for Business Law at Allard, and her technical team, led by Sonia Lee Trottier, to Executive Director James Cohen and Chair Suzanne Cote-Freeman of Transparency International Canada for your continuing leadership and support for the anti-corruption law program, which comes in so many ways. And of course, TI Canada is well represented today on our panel with two experts from the legal committee of TI Canada. And as well to Peter German, who's president, and Joanne Macri, who is the executive director of ICLR, for your ongoing support for our program right from its inception. And I want to give my personal thanks in advance to the panelists for their work today. It's my pleasure now to turn proceedings over to our moderator, Peter Dent. Peter Dent, for many years, both at the national and international level, has been a leader in the anti-corruption movement. He's had career stops in a variety of positions, including the Forensic Services Unit of the World Bank, 3 years at the UN Development Program, where he was involved in evaluating and strengthening the accountability and transparency of the UNDP's procurement processes. He is past chair and an ongoing driving force of TI Canada. Work closely both at the municipal level and with the RCMP commercial crime unit. He's really an inspiration and has been a regular contributor to the anti-corruption law program. And in his day job, he's a partner with Deloitte's forensic practice. So with that, I turn it over to Peter Dent. Thank you.
Thank you very much, Joseph, and thank you to each of my fellow panelists as well today. I think we've got a very distinguished panel in front of us and with me this morning, and I'd ask that they turn on their cameras now so that as we sort of do our quick sort of round the table, we can kick things off relatively quickly. We're not going to do a detailed introduction. I think that everyone's backgrounds are available for folks to review as they see fit. And all I can say is I'm honored to be here with each of them. And so what I want to do is I just want to start kicking things off immediately with respect to some of the questions that we'll be posing to the panel. But I would also like to start with a bit of housekeeping. And the housekeeping is that those that are on the webinar are more than welcome to enter questions in the Q&A forum. And so I won't wait until the end of the session to turn some of these questions to the panel as well. What I'll do is I will, as a topic is being discussed, if there are questions around that topic from the audience, I will certainly be willing to put those to the panel. The more difficult the questions, the more pleased I will be to put them to the panel as well. As my job as moderator is one to keep the ball rolling. And so one of the things I'd like to do is to and sort of explore the rationale and the objective of the federal government. And just to remind everybody, they did announce just prior to the last federal election that we're going to create a national law enforcement agency to be responsible for financial crime. And they define financial crime as things like insider trading, organized crime, and money laundering. Just to name a few areas. And so now that of course would be a dynamic change in Canada in terms of the enforcement of economic crime. And so one of the things that I'd like to have the panel address, and Jennifer, I'm gonna start with you just to give you some preliminary warning, but I'd just like to understand your perspective with respect to what might this national law enforcement agency do differently as compared to the current structures that are in place right now in terms of how we combat economic crime in Canada.
Well, thanks for that introduction, Peter, and happy to jump in and be the first one. Although my perspectives are simply my perspectives, I don't have any magic answers to the challenges, and there are many. We'll certainly get into a number of them today, I expect. I think what I see as the possible way to imagine a financial crimes agency would have to start with some delineation of what that agency would do. And we have examples in many other countries of a centralized agency that's responsible for enforcement in relation to what I will put in quotation marks is financial crime. But each country has a slightly different jurisdiction that's delineated, and that has to do a lot with whether or not it's a unified, a unitary country, or like us, a federal country. And so when you have two layers of government responsible for different aspects of government, you can't necessarily just say, oh, we're going to put this all together. And financial crime as a category is pretty large. But where I see the biggest need, and then I'm happy to follow up and let others speak first, is in the area of corruption and anti-corruption enforcement, because in particular, foreign corruption is clearly federal jurisdiction. And in relation to that, you have some criminal code offenses which are also, closely tied to that. In, I think of fraud in particular, but also money laundering and some of these other. And these are offenses where, larger investigations have to happen. Often they are more complicated because they involve more than one level of enforcement agency or cooperation with external or foreign agencies. And this is an area where right now there is no, and I'll put it in quotation marks, fairy godmother of corruption enforcement. There's no entity that's designated as having the responsibility and the accountability vis-a-vis the public in a clear way. Now, I know the RCMP has its, has a special section, but that's not very visible. And I think if we want to look for an example, not necessarily that we would copy, but in Canada, we do have an agency that is charged and tasked with all things related to the enforcement of the Competition Act. And it's clearly identifiable. It has its own website. It provides its own communications. It's very proactive. You can criticize, how it does its job, but it's very clear in the minds of Canadians, who's in charge of competition. And if there is talk of amendments as there is now, there's a clear place to organize that discussion. There isn't such a thing for corruption. I'll leave it there.
Thank you, Jennifer. And I think that also it would be beneficial to have some insights from Peter German in terms of his past experience with the RCMP and in his many years with them and rising to the level of the deputy commissioner. And sort of, and I'll put some context around that. And that is, there was an article in the last couple of weeks that came out, and a senior member of the RCMP was quoted as saying that the number of Canadian corporations that are coming forward and, for lack of a better way of putting it, confessing their sins around foreign corruption has increased in order to take advantage of, sort of the mitigation of any eventual fine. So with that coming, but that's not really my question to talk about that, maybe an area to explore later in our discussion. But one of his comments was that it was still going to take the RCMP 4 years to run an investigation where a corporation is coming forward and self-identifying the issue and assisting with full cooperation to law enforcement. That seems like an astonishingly long time. But Peter, those are my words. I think everybody can benefit from your perspective of that.
Well, thank you very much, Peter. And I'd like to, at the outset, thank John and Joe for putting this together. There's a lot that goes into it, and it's really appreciated, as well as to the Center for Business Law at Allard, who has staunchly supported these workshops for so long. So thank you. And also thank you to you, Peter, for taking on this task and your little extra in addition to your normal day job. Yeah, that's a pretty shocking quotation when you think of it, or a shocking comment. Whether the inspector who made it, whether he was quoted properly or not, I don't know. But it should shock Canadians that we can't get to a mediated agreement in 4 years. And that's just the investigative stage. So, we can easily say, well, it's the problem of the police. And that is, in my view, entirely simplistic. We've got fundamental issues that have to be dealt with here. Policing is a part of it, no doubt about it. Jurisdiction, but I'm going to give you what I'm going to call the 6 Ps. And I'll just sort of throw those out, and we can look at them as we go along, or if you're interested. The first, and Jennifer touched on this, is provinces. We do live in a federal system, and the provinces play a huge role. They actually enforce the criminal code, and most financial crime falls into their remit. If you look at sheer numbers, I received 2 phone calls this morning before going on here at 9 o'clock. Both were robocalls. I mean, we're all being inundated by telemarketing, fraud, et cetera, et cetera. So the great bulk of financial crime really falls in the provincial domain unless you can show some reason for the feds to be involved. The other one is privacy. The second one is privacy. We have very strong privacy laws in this country, and we like that as individuals, but it really impacts on the ability to do the job of law enforcement. Prosecution. Our prosecutors, I would say, are second to none. We have excellent prosecutors, but our prosecutors, and it'd be interesting to hear from others, function differently in Canada than you will see in other jurisdictions where they consider themselves part of law enforcement, and it's sort of going down the road together. We don't do that here. Policing is obviously an issue, and I've already touched on that. Priority. It's about government priorities. Now, Peter, this is all about an announcement about a financial crime agency, but we really don't have much fat on the bones at this point. We don't know if this is new money, if this is money that's coming from already dedicated funds given to, let's say, the RCMP and others. So where does it fit? In BC right now, I can tell you people aren't interested in financial crime. They're interested in floods in the Fraser Valley. But, if you look at this holistically, where does financial crime fit? I suggest we should be paying a lot more attention to it than we are as Canadians, because it does fundamentally impact on all of us. And I would then throw in pressure. In Canada, we've got very strong lobby groups, which are almost disproportionately strong compared to, let's say in the United States. The banking lobby has been very strong and instrumental in how our proceeds legislation was drafted and rolled out. The legal profession, very strong. Legal profession, aspects of the legal profession opposed proceeds of crime legislation adamantly at the beginning. And you see a continuing lobbying. So I don't think simplistic solutions are going to get us anywhere. We have to have a discussion about these bigger issues, and I threw out the 6 Ps, so to speak, and I'll stop there. Thank you.
Thank you. Thank you very much, Peter. And we're very fortunate to have Mary Inman with us today as well, and coming from her practice both in the US and the UK, where she assists whistleblowers taking issues such as this to the regulators in those countries. And so it would be beneficial to get the US perspective. I mean, is this 4 years sort of comment from the RCMP? Is that also something that we would typically, or you would typically see from the US DOJ?
Thank you so much, Peter, and thanks for having me on board today as the American voice here. I do want to clarify that I actually, in addition to helping whistleblowers in the UK and the US, I actually help whistleblowers under Canada's own whistleblower reward programs, which include the Ontario Securities Commission, as well as the Canada Revenue Agency's OTIP, Offshore Tax Informant Program. So don't want to leave Canada out. You have reward programs also. When a company is self-reporting, we do a lot better than the 4 years. And I think part of that is just because the DOJ can deal in a centralized way and activate quickly. There's great channels of communication among and between, just like Canada, we have a federal government and state governments. There's a lot of well-trodden paths of coordination and collaboration between the two. There can sometimes be fiefdoms and turf wars. You can have DOJ and the Southern District of New York duking it out for primary lead responsibility, but for the most part, coordination happens well. And we move pretty quickly in processing a company's voluntary disclosure. So definitely less than 4 years.
Thanks for that, Mary. And that's not surprising to me, having worked with companies that are facing off against the US DOJ myself, as there's a degree of efficiency we see in the US, not to say anything about perhaps a profit motive there as well from the US agencies. So Anthony, I'm going to come to you next and sort of try to explore, or help, maybe you can help explore how this national agency might change or improve or not the overall strategy of the Canadian government around economic crime, and maybe even backpedal a little bit on that, or back up a little bit on that, and give us perspective on is there a national strategy in Canada?
So I can give a very short answer to that question. No, I don't think there is. And I think that is part of the problem. Both Peter and Jennifer have spoken to, well, first of all, financial crime is a very large group of crimes that have, the provincial authorities have responsibility for, as Peter said. Corruption, the foreign corruption legislation in Canada, the CFPOA, does have exclusive federal jurisdiction with the RCMP, and it is typically prosecuted by federal prosecutors. There has been one exception where it was prosecuted by provincial prosecutors, but that was for specific reasons that meant that the feds were not able to take that case on. But nonetheless, you have these different areas of responsibility for different areas of crime. And I think one of the issues is that the announcement around the National Financial Crime Agency is very short on details as to what it's supposed to do, what it encompasses. The crimes of money laundering, insider trading was specifically mentioned. Corruption was notably absent from it, which struck me. I don't know if that was intentional, or it is not intended that it's going to form part of the mandate of this National Crime Agency. But to me, foreign corruption is one area where it may make sense to have a national financial crime agency, because it is an area where the RCMP have exclusive responsibility, where you have federal prosecutors. And it being cross-border international in nature is probably well suited to having a federal agency pursuing it. So in one sense, going narrow and having it dedicated to foreign corruption may make some sense. On the other hand, if that is not what is intended, and it is intended to cover a broader suite, then I think we have to ask, what can we achieve with the various competing, and they're not necessarily competing, that's the wrong word. They could be complementary, but the various agencies involved, law enforcement bodies involved, and the different approaches to tackling, say, an insider trading case, to a money laundering case, to organized crime is mentioned in sort of a generic sense in the announcement around the National Crime Agency. All of those are very different investigations. Foreign corruption, very different type of investigation. So trying to have a National Crime Agency that sort of generically deals with all these things. They mentioned FinTrack's going to be part of this, CRA is going to be part of this. Well, how? There doesn't seem to be any coordination. I think that is one of the problems we have in Canada. Is we've got law enforcement bodies, we've got good law enforcement bodies with excellent investigators, we've got prosecutors who are maybe excellent prosecutors, but in terms of a coordinated strategy, it's absent. What we don't have is a coherent policy vision. It's being left to politicians, essentially, to push that down, or to make these announcements that are quite generic in scope. They may be a bit potted, not coordinated, flavor of the month, rather than having a single body that can understand and prioritize what is it about financial crime that is of greatest interest to Canadians. What is the strategic priority, which will shift over time, and then can build some momentum and some policy initiatives around, okay, well, what will it take to tackle that? So in the case of money laundering, is it legislative change? In which case, coordinate with the various stakeholders to try and bring about the specific legislative change that is going to address the specific issue of priority. Similarly, if it's a question of enforcement resources or a type of enforcement tool like remediation agreements, it gets behind that. And it has a national voice, it has a presence that can, as I say, engage with the multiple stakeholders, the law enforcement bodies like the RCMP, prosecutor, the PPSC, the provinces, and the politicians, and as I say, drive a national strategy. To me, that's what's missing, and that may be the most fruitful route through. I'm not sure that's what is intended. So that's my perspective, at least. I think having a role in as I say, the development or the prioritization of specific components, and really having experts who can understand what it's going to take to successfully enforce that strategic priority would be a very helpful thing.
Thank you. Thank you very much for that, Anthony. And we're going to be talking about the next area, which is, and we'll cover off some of the questions coming in from the audience as well during this next discussion. But are there arguments, and Peter, I'm going to start with you again, just so you know, coming in your direction. And are there arguments in favor of retaining the existing enforcement structure within Canada, and leaving it with the RCMP in terms of modifying how they do their work, reorganizing, restructuring, anything like that?
Yeah, thanks, Peter. I'm a strong believer in a certain amount of consistency. And one thing about the U.S. agencies that I quite like is that there are a lot of federal agencies in the U.S. dedicated to enforcement of one sort or another. You've got your FBI, Secret Service, postal inspectors, et cetera, Homeland Security, it goes on and on. But they've all got their own mandate. And yes, a lot of the mandates are overlapping, but it actually works. And much as Mary mentioned, they've been doing this for a long time. And they don't just necessarily throw the baby out with the bathwater, so to speak. We tend to think, okay, we've got a problem here, and we look for a simplistic solution, kill that agency, create a new one. And there's a long history of us doing those sorts of things in Canada. So I don't think this is strictly an RCMP problem. I think that's a simplistic answer. Yes, the RCMP, and I've been quite critical of what's happened to the financial crime program in the RCMP, but there's reasons why it has decreased in priority within the force. And it's for a number of the issues that I outlined earlier. Getting a conviction in financial crime, a high-end financial crime, is extremely difficult these days. And we could talk about all of those areas, such as stinchcomb and disclosure and timing and so forth. So I don't think the simplistic solution works. I think the RCMP is positioned to deal with certain of this work. But again, it's that federal provincial thing. So, I think Anthony is 100% correct. We need an overarching national strategy. And when you have an overarching national strategy, whether it's on money laundering, corruption, organized crime, or all of the above, then you can start putting this together in a coordinated fashion. We don't have that right now. So we're doing the, picking here and picking there. And Peter, if I may, I don't know if that answers the question, but I'll throw that out anyway. If I may just I've complimented Anthony, but I'm also going to take exception with him on one point, and that is if we talk about this strictly the tip of the iceberg, international anti-corruption, it's interesting what has happened there. And this is almost symptomatic of our issues in Canada. The idea that the RCMP has sole jurisdiction there, I would say they don't. In fact, the very first corruption of foreign public officials case in this country was a U.S. border officer who was corrupted in the state of Saskatchewan, or in the province of Saskatchewan. So it actually occurred in Canada. It was a foreign public official corrupted in Canada. The charge could easily have been laid right under our criminal code. The original CFPOA did not reference the RCMP. There was an amendment, I believe it was 2013, where the RCMP was given exclusive jurisdiction to lay charges. It's a very unusual amendment. I think it's wrong. I don't think it should be there, because essentially other police forces go away and they say, hey, we've got no part to play here. It's the RCMPs. The question has never been satisfactorily answered why that provision was put in our CFPOA, that only the RCMP. And I suspect the answer is more administrative than anything else. So I'll leave it there and hope that answered the question.
Thanks very much for that, Peter. And I'm going to come to Jennifer next, and then I'm also going to pose a question, and hopefully the panelists can also answer this one as well. And this comes from the audience. How is this going to be? As I asked Peter, how would a new agency be any different? And what is it about this new agency that would make it better or improve? And wouldn't the existing impediments, some of which Peter German has alluded to already, exist for any new agency as well? But Jennifer, in terms of the overall context of the question, it would be good to get your insight as well.
Well, thanks for the question. I think it's incumbent on those of us who believe an agency could contribute to have an answer to this question, even though I think that it's very important to retain the fact that these things still need to be the product of a conversation. I want to just take a tiny step back first to come back to something Anthony mentioned about the importance of a strategic vision. To that, I would add, and we can get into this later if you like, the notion of financial crimes itself is problematic in that we're talking about focusing on something that has a financial characteristic, and part of the enforcement strategic vision, in my vision, should actually articulate why we care about these crimes. And I am not convinced that focusing on the financial characteristic of the crime is necessarily getting to the heart at why these things bother us. And I think particularly of foreign corruption, which raises issues that relate to economic development and trade, but also relate to the potential impacts on human rights and on concerns that you would say are actually much more about criminal law generally, about physical violence, about danger and that kind of thing. So one of the things that we need to establish up front when you talk about an agency like this is what's their role in advancing the goals of why we prohibit these behaviors. So I'm going to park that, but I think it's important to remember that we talk about financial crime. It's not just because it's about money. And I think we can get caught up in the fact that it's about money as somehow that's different from murder and sexual assault and other types of, you know, grubby crimes that only happen in Canada. I think the reason these things bother us is because they have ramifications beyond the money. But the money is kind of that creates the incentive to engage in these behaviors. I'll stop there. In terms of the agency, however, I do think that what would be different about it, and perhaps I'm optimistic, but you know, I'm old enough to have some long view, is that you would consolidate expertise in one place, and you would allow that expertise to develop. And although, yes, there are specialized units in the RCMP, my understanding is those units get cannibalized for resources and reasons of advancement, and it makes it difficult to keep those people there and keep them engaged. Now, of course, you can't tether someone to a choice of career forever. Okay? But if you look at the Competition Bureau, which again, can be criticized, it's not perfect, it's, you know, many people think that maybe it's not the best thing. There are many career officers there. These are people who are not necessarily law enforcement, but have developed expertise that's relevant to competition, but they do investigate criminal matters, sometimes in collaboration with police forces, but they approach it vis-a-vis the mandate of promoting competition. So that's the first thing. Two other things, and then I'll pass it on to others. The second thing is that the competition agency has a mandate across a spectrum of enforcement responses, not just criminal prosecution. And I think we have to get out of the mindset that criminal prosecution is the only way we can convey that we take things seriously. You know, the fact is that there's a huge, and you know, Anthony and I know lots of these people through Transparency International, there's a huge group of people who work on compliance and ethical business practices. That has to be part of the conversation, and that should be coherent with the strategies on enforcement. And part of the expertise that can develop is not just how to prosecute, but how do we provide, for example, to small and medium-sized business or to businesses that are launching into the international arena for the first time, examples of good compliance, examples of procedures and policies you should have to protect yourself. Now, obviously, there's a sector of the private bar that can provide that advice too, but I think there needs to be a consistency there. And the third thing, and this I really think is important, this is my law professor hat, is transparency. Right now, there is an opacity to enforcement in this area that makes it very difficult for anyone who's not inside and in the hallways listening to these conversations to know what's going on. And I think that that is a serious problem for the public and for the legitimacy of enforcement. It should be possible to find out what's going on, what's being investigated within the confines of respecting confidentiality and so on, and for people to be able to go to one place and find out what's happening. That tends to militate in favor of a narrower mandate. And I think that's why the US system works so well. People know where to go. They know what agency is responsible. And those agencies have a way of working together. I'll stop there.
Thanks, Vera. That's excellent. And Anthony, I'd be curious to explore the same topic with you and see if you have any comments around that. Wouldn't the current impediments that exist already in Canada and sort of the structural and judicial and legal frameworks, wouldn't they also create the same impediments for any new agency?
I think, and yes, but one of the, and this comes back to what this is and what its function is. I'm not convinced, you know, we need to start dismantling units of the RCMP or, you know, units of other Ontario Serious Fraud Office, those sorts of things, and start collapsing them into some kind of national financial crime agency. On the contrary, I think it's going to be far more efficient. We'll get much better bang for buck, and actually it will be more targeted to what Canada needs. If it's more of an oversight or a sort of a strategic body that is responsible for engaging with these various stakeholders, not doing away with them or even subsuming their investigators, but having experts who can work with the various stakeholders on issues of a coordination, on setting priorities. And I'll come back to one of the things Jennifer mentioned on what one of those priorities might be, but also help those agencies, those enforcement bodies or units have a voice, again, at a political level or a public relations level, to get, you know, what they feel they need, as well as both to work together. So, privacy adjustments, resourcing, setting a priority. If say money laundering or the impact of housing, of money laundering on house pricing is going to be an issue of strategic priority, well, how to bring the various enforcement stakeholders together, and regulatory stakeholders, FinTrack as well, CRA, okay, well, each playing your own roles, how can we coordinate this to actually make a dent in it, do research, work with, academia as well on, research issues to identify, again, shortfalls, what other countries are doing. But really it's almost a sort of both a center of excellence and a strategic voice, and priority, a goal setter, rather than an actual enforcement agency. I think there's a lot of clearing out. There's going to be a lot of competing interests. I'm just not sure how that's even possible. It's an enormous undertaking, unless it is, say, very narrowly focused on something like foreign corruption, which, to be clear, Peter made a fair point. I'm not necessarily advocating that should be the case. On the contrary, I'd actually like to see something more, well, I say on the contrary, that's certainly one model that could be pursued. But if we're talking about a more ambitious project, it would be, to me, focus more on that kind of, that strategy building, stakeholder engagement, the political engagement, rather than, taking people's enforcement responsibilities and trying to jam them into an agency. One last thing I'll say, and it comes back to Jennifer's mentioned, I think we might touch on this later, but corporate engagement as well. So it's not just enforcement engagement, it's also corporate engagement. And one of the most important things there is, the upfront compliance framework. There is very little incentive in Canada to take upfront compliance seriously, aside from the money laundering space, where for certain sectors of the economy, certain types of businesses, there are some very granular obligations that are, complied with in some industries better than they are in others, in some areas better than they are in others. But in an area like foreign corruption, within the remediation agreement regime, there's an incentive to get your house corrected going forward, and it's an important part of that regime. One thing that, to me, that was missing, that is in the UK regime, that is in the US regime, is an incentive to get your compliance in order up front, i.e. it's a credit factor. If you already had a compliance program, even if it went wrong, even if something, slipped through the net, having an incentive to actually be proactive about it is sorely missing. Again, why? To me, because the right stakeholders probably weren't at the table when that framework was being drawn up. Or at least they didn't have a strong enough voice. So again, that's something I think an example of somewhere where a national crime agency can, or a national financial crime agency can assist, as well as, say, encouraging that compliance, being a resource for companies looking to enhance their compliance practices, or get an understanding of what the expectations are among law enforcement, and having a body that can speak for those priorities as well.
Thanks very much, Anthony. And Mary, obviously over to you for any of your insights, but also I want to be a little bit unfair to you and roll in a couple of questions that have come in through the Q&A chat as well. So a bit of a sandbagging opportunity here. And so, we talk about structural differences between the US and Canada, but also Canada and other jurisdictions. The national nature of the other jurisdictions like the UK and the US, even from a securities regulator standpoint, but also from a national law enforcement standpoint. One of the questions we're getting is around the skill set of the people that actually are in these units, and what sort of skill sets there are. So to the extent you can share your insights into, the FBI's white collar crime group, what does a typical FBI agent look like in an organization like that? And even from the UK's perspective at the SFO, what does a typical economic crime individual look like in terms of their education, their experience, their background? I think that might be insightful as well.
Happy to comment on that. So for our FBI agents in particular, they all go through a general type of training in Quantico, which is the center in the US for all education of FBI agents. But to your point, what happens after that is we specialize them, right? So you have, we specialize them based largely on our enforcement priorities. So there is an organized crime unit, there is a virtual currency task force, there is now for cyber breaches and the impact on that on our financial system. So we get training, and so it's not, we would have a specialized forensic accountant FBI agent with accounting background and auditor functions. So I think it's important to recognize this, that we do break into specialized units based on where we think our priority areas are. But I did want to draw another distinction, which is that for things that we're talking about today, like insider trading or violations of bribery of government officials, there is a real hand-in-glove relationship between the regulator and the Department of Justice. So for instance, the SEC, CFTC can have jurisdiction over money laundering. That's our agencies that are there to protect the markets, but they only have civil enforcement. And so they need to coordinate with DOJ criminal. And that's just that is a dance that is well orchestrated and well known. So from inception, for instance, if it's a whistleblower initiated or just a regularly initiated insider trading case, for example, the Securities Commission team at the SEC will be quickly folding in the criminal FBI and prosecutors from DOJ to be tracking at the same time, realizing that their enforcement is limited to civil on the SEC versus criminal. So they get the benefit of the SEC's specialized expertise in this area too. And I think something, you could do something similar, obviously in Canada with the federal securities the provincial level of the securities regulators, you'd have to do it province by province, but they need to be able to coordinate with someone specific. And I think a financial crimes agency would be very helpful for that.
Thanks, Mary. And Mary, I do want to just stick with you for a moment as a follow-up question. And that is around the concern, because another question we got, which is the reason I'm asking you, is that it's specific to the U.S. jurisdiction. And the U.S. jurisdiction, in that the agency that is responsible for the enforcement of the regulatory action being taken gets some or all of the money that is assessed or levied against the organization or the company in question. I've heard through my own dealings some grumblings in the corporate world that that is incentivized or created a profit motive that may not be always in the best interests as a whole, and may create incentives to abuse the process and further fund the coffers of enforcement agencies, rather than looking at what is the downstream objective of the overall regulatory action. Anyways, over to you.
I think it's a fair criticism. I would take issue and say there's a instead of a dark, unseemly underbelly, there's actually a really positive thing that comes out of that, which is we actually have just hired someone who used to be the director of the SEC's regional office in Chicago. His name's Joel Levin, and he basically talked about the healthy competition that happens when a particular tip comes in for each agency to want to get it. And so there's that financial piece is one piece of it, but people are hungry and are positioning themselves to get the best cases. What I think is remarkable in this is my long time in this space is I've been helping whistleblowers bring information to the federal government for 25 years. And when we first started doing this, no one, any other U.S. attorney's office, they would just sort of say, oh, okay, that's fine. And now in the past 10 years, they actually have specialized conferences where they bring the whistleblower bar together and say, bring it with us in the Southern District of New York. I know you have options, bring it with us. And they do a dog and pony show to say, we have better agents, we have better specialized units and things like that. So there's a lot of healthy competition to grab the best cases, either, as you said, to get the funding, but I think more importantly, because that's your raison d'etre, is to be the regional office with the best track record for enforcement actions.
Thank you very much for that, Mary. Very, very insightful, and I know that it's consistent with certainly some of the grumblings I've heard out there as well. And Peter, coming back to you, I mean, there's been a great deal of discussion around comparisons with other law enforcement agencies. I mean, what are the key, from your perspective, in your years working, not only within Canada, but I know that you've liaised with other international law enforcement agencies as well. What are the key lessons learned that you think that, whether it stays with the RCMP or a new agency is set up, what are the lessons learned that we could take away and make sure are in place going forward?
That's a tough one, Peter. What I would say on one level is that police tend to work, law enforcement tends to work pretty well together on issues in this country, and also collaboratively internationally. That tends not to be a big issue. And the more urgent the situation, the better the cooperation, quite frankly. People tend to band together. We don't have, I would say, competition between agencies like you might see elsewhere. I get Mary's point that can be positive in a certain context, but we don't see that as much. The issue is really oftentimes finding someone to take on these cases in the first place, and selling a case can be difficult. But that also applies to the prosecution service. I've investigated high-profile corruption cases where I couldn't find a prosecutor prepared to take on the case, and you essentially have to sell it. And that's almost the opposite of what Mary is talking about. In terms of, the police officers themselves and how they're constituted, I mean, you've got some very, very experienced people in police departments, and you've got, with a lot of expertise, you've got accountants, you've got people with legal backgrounds and so forth. The Canadian model, though, is to hire forensic accountants if you need forensic accountants. It's to use your your people with an accounting background as investigators rather than as forensic accountants. So essentially, their background helps them in terms of discerning what is relevant and what isn't, but then you still rely on contract help. But we dealt with these issues through the years. For example, we're talking about a liaison between the securities commissions and the police. That was intended to be the focus of the integrated market enforcement teams, which still exist in Canada, the IMETs, was to have that close coordination. In fact, we located them, almost co-located them, almost next door to the securities commissions. But in Canada, we've got, some unique legal issues when it comes to regulatory versus criminal space. And we don't have that nicely coordinated dance that Mary was talking about between agencies. We've got, some Supreme Court of Canada cases which really keep the criminal and the regulatory quite separate. So, for a lot of reasons, agencies aren't able to work together. On maybe a more strategic answer to your question, and it gets back to my thing about let's be careful what we throw out when we're trying to create something. I started in policing 50 years ago this year. That's a long time. So I've gone through this iteration once before in terms of the RCMP security service. I was in the security service many, many years ago, and that evolved into what we now have as CSIS. And that was a case of throw out the RCMP, we want a whole new agency. CSIS does a great job, I'm sure, but it took a long time to get there. We're talking probably 10 years or so, and there were some real hard knocks along the way. The Air India case is one in particular that stands out in terms of How do you situate yourself with international agencies? How do you situate yourself with domestic agencies? How do you liaise with the police? Who can you talk to and who can't? So we have to be really careful when we decide to start with a, just all over again, essentially. We've got some really good agencies already working in Canada, but for various reasons, such as the ones my 6 Ps from earlier, there are some real huge impediments that I think we have to look at. And Peter, if I may just, I'm going all over the place, but if I may just pick up on a couple of points that Jennifer made earlier, I really like what Jennifer pointed out in terms of there's a bigger picture than enforcement here. And certainly we know that there's a tipping point in countries. We've seen those countries where organized crime basically runs the country. And that quickly gets you into the human rights issue. It gets you into issues of developing world, kleptocracy, all of those. But you also see that in terms of, let's say, drug enforcement. Take a look at the downtown east side of Vancouver. It's getting worse. And despite everything that, federal government, provincial government, and so forth are doing, there are more and more people on the streets. I'd say we've reached a tipping point in terms of the downtown east side, and people are looking for these same simplistic solutions there. But those solutions are not easy to find. It really does require coordination. The other thing I would just point out, throw into the mix here, is Quebec. Quebec has really been a leader in this country in terms of anti-corruption measures through the years. They've had a lot of corruption to deal with, admittedly, in the province, but they've also been a leader in terms of legislation, pressuring for new legislation, but also in terms of commissions of inquiry. And the most recent, of course, that we all remember is the Charbonneau Commission. And Charbonneau gave rise to an anti-corruption unit, 300 some people in it, half doing enforcement and half doing the audit function. So getting back to Jennifer's comment, they realized this isn't all about enforcement. It's about changing how we do business in the in the construction sector, so that it's not a corrupt sector. Now, I realize they've had some criticism recently in that agency, but it certainly was a great step forward. So I'll stop there. I've thrown a number of things back at you, but hopefully I somehow answered the question.
No, I appreciate that very much, Peter. And Jennifer, it would be good to understand from you, and again, I'm going to be a little bit unfair that I'm going to pack in a question coming in through the Q&A chat as well, to get your perspective here. And I wonder whether or not, in terms of the structure, in terms of sort of the lessons learned with other jurisdictions, everything we're talking about, the comments from Peter and Mary before you, is there a possibility that this new agency can tackle financial crime more holistically?
I will try to put on my optimist's hat, which is not a hat I wear very often, but I'll try to do that. Listen, the first thing is I'm going to come back to the definition. I mean, I think financial crimes that's way too broad. Okay, to the extent you could throw, securities reg and all kinds of other things into that. I think that is too ambitious. And I would come back to something Mary said, about the different agencies in the U.S. I think that one of the things that we might want to think about, and I've been thinking about this in a different context, so apologize if this sounds a bit odd, but sometimes the way situations present themselves, or let's say problems that we want a solution to present themselves, don't fit the categories, the traditional categories. And, law has to be flexible to some extent to allow for these new circumstances. And there is a certain amount of flexibility that should be, just as you go kind of thing. So the categories can be stretched, we can adapt the criteria, but there will come moments where it might be time to clean house, or at least to take a step back and reconsider, where do we need to put the foundation? And maybe we're at that stage now, not just in relation to, financial crime, but more generally when we talk about regulation of the economy. I just put that there because there are a lot of things that we're trying to do with economic policy and with enforcement right now, and we might have to have a little bit of a reality check as to how many objectives we can pursue at the same time. And you know, Canada does continue to adhere to and engage itself in international commitments that mean that sometimes its enforcement lens has to be beyond Canada. So, you know, this complicates things, particularly when I'm thinking of, you know, foreign corruption, but also other areas of economic regulation. If we think about, you know, money laundering and so forth, those have international dimensions, and we have an obligation in there. However, getting back to the agency, I do think there are some things we could learn from elsewhere. I'm going to start in reverse order. Peter talked about Quebec. Lots of people think about UPAC, that's the Unité Policière Anticorruption, or the, you know, anti-corruption police unit in Quebec, but that's not the only part of the post-Charbonneau world. Far more significant to my mind is the Autorité des Marchés Publics, which is the regulatory agency that was created originally after the Charbonneau Commission. They temporarily parked responsibility for determining, you know, who would be debarred from public tendering with the financial regulator, and very quickly it became complicated to do that. So they created a separate agency, which really has as a mandate to, you know, look at these kinds of circumstances. So this is an agency that can determine, you know, who should be allowed to tender. Basically, it's, you know, an eligibility and ineligibility list, but it's kept separate from the financial regulator, and it's part and parcel of this system where you say, look, we need to keep tabs on, you know, who's playing by the rules and who isn't, and we need to administer this in an orderly, transparent way. And they did that. So I think that that's something to consider. That's a civil entity. That's not criminal enforcement. But debarment is a very companies pay attention to debarment. And debarment, for those who are not criminal lawyers or versed in criminal law in Canada, debarment is not something a prosecutor can offer. And even under the remediation agreement regime, in fact, that's one of the reasons why it exists. Prosecutors cannot offer debarment. That's a protection from debarment. That's something that it comes out of the authority of the governments who establish their tendering rules in Canada. And remediation agreements provide a way to avoid the conviction that would normally trigger debarment. So, you know, I think we need to maybe think about, you know, that there's more than one way to skin this cat, and that some of the tools are not criminal law tools. But an agency that has a mandate, and I'm going to go back, I'm going to make myself a target and say, look, I think we should choose an area more narrowly and think about an anti-corruption agency, for example, or something that deals with those types of behaviors. Then you can start to say, look, there's not just criminal prosecution. There has to be a reasonable prospect that enforcement and tough enforcement in the form of a contested case could happen, but there are other tools and other ways to get at this. And I think that you cannot get away, Peter's mentioned it, Anthony's mentioned it, you cannot get away from the need to cooperate. One of the things that we need to think about is memorandums of understanding between the enforcement agencies, so those who investigate, so whether that's the RCMP or a special unit of investigators, or maybe both. Maybe you have some, you know, some more criminal investigation focused things could still remain with the RCMP, and then you have civil investigators perhaps within this new agency. You have to have memoranda of understanding then with the legal counsel who bring the cases, and especially with the prosecution service. The reticence of Canadian prosecutors to bring cases, and then I will stop because I'm taking too much time, but I think it's important because this is a big difference with the US. Part of the reticence of Canadian prosecutors is that bringing cases, especially against business organizations, is difficult. We do not have a respondeat superior basis of liability. We have a modified identification doctrine. You can call it what you want. The rules are in the criminal code. And for an offense like corruption or fraud or anything with a subjective mens rea, so that's recklessness, intention, or knowledge, and willful blindness fits in there too, you have to have strong evidence, and you need to find a senior officer who has that mental state. This really increases the stakes and the uncertainty of a trial, which is, I think, one of the reasons that contributes to the length of investigations. The amount of evidence that a prosecutor wants in order to meet the criteria to start a prosecution, which is reasonable prospect of conviction plus in the public interest. I think that that's part of the factor. So I don't think we can get away from the fact that there are legal impediments in the Canadian system, but I do think a central agency might create some weight and some strength behind and some coherence behind what we need to change and for what reason. And maybe we need more than one agency. I know that's the wrong thing to say, but I think that the concentration of interest, the focus on the goals, the broader view of all the tools you can bring to bear, not just criminal prosecution, is really important to the success of this kind of endeavor.
Thank you very much, Jennifer. And Anthony, I think everybody would benefit from a perspective and your sort of insights with respect to what Jennifer has just been raising as well, from a structural impediment perspective, but also just following up from some of Mary's comments around information sharing between the FBI and the SEC. How effective can the RCMP or any new agency be in terms of information sharing, whether that be between the RCMP or the new agency in FinTrack, between the CRA, there's all sorts of other sort of information sharing that can take place, but how easily can it take place in the Canadian landscape?
Yeah, so lots to unpack there. I mean, at a broad level, there are a lot of impediments in the Canadian landscape, and I think the first thing I'm going to say is I'm not sure. The US is a natural model for everyone to look to with financial crime enforcement because it's been largely successful. It's far more successful than any other jurisdiction if you just can take the metrics of number of cases brought, magnitude of fines, those sorts of things. But there are two things that are particularly important to bear in mind. One is their law enforcement bodies responsible for those things, particularly at the broad level. So, DOJ, SEC are enormously well resourced in a way that Canada is not and never will be. We just don't have the scale of resources, and I cannot see any prospect of that happening even on a proportionate scale, even recognizing the smaller size of the Canadian economy and the sheer population numbers. It's just not going to happen. So I think we have to be realistic about that. Secondly, if we're taking foreign corruption, talking about the collaboration between the SEC and the DOJ, in Canada, we do not have a national securities regulator. We have provincial securities regulators. And particularly with something like corruption, why should Alberta Securities Commission take an interest in foreign corruption cases and treat that as part of its strategic priority? It really doesn't affect the Alberta markets an awful lot. You could make some arguments how it might do indirectly, but there are bigger fish to fry, and why would it allocate part of its budget to participating in that? So I think that's just one example of why there are material differences between us and the US, and I'm not sure the US is the natural model for us to look to. Where else might we? I mean, we could look to the UK. That's another obvious one to look to, but again, that's a unitary system. It doesn't have the same number of competing, again, I use that word, it's the wrong word, it's not competing agencies, but multi sort of jurisdictional layers, different levels of responsibility. So I think that's a problem as well. This is why I come back to so two models, one being a coordinating body. So it addresses some of these policy questions you're talking about, Peter, the sharing of information. So that's a very complex question that may require legislative change, greater policy use of MOUs, a more sort of institutional receptiveness to that as well, a more institutional receptiveness to some element of risk-taking and allowing courts to basically test these in front of the courts, recognizing that Canadian courts are a lot less prosecutor-friendly than the US courts are typically. Our prosecutors get a pretty hard ride from the courts. They are held to a very, very high standard, even compared to the UK. But certainly in relation to the US, the prospects of conviction there, I think, are higher in financial crime cases. Nonetheless, which I think has bred a degree of conservatism, understandable conservatism. But again, it's an agency that can identify these issues and come up with solutions, get the stakeholders involved and have a strategy around, okay, so we have a problem with information sharing. What are the obstacles and how do we overcome them? If it's legislative, then it has responsibility either on its own bat or say with the support of the other agent, with the law enforcement bodies that are stakeholders in this, pushing for that change, rather than, again, the way we do it at the moment is the RCMP isn't going to make the move for that. The PPSC is not going to make the move for that because it's an overtly sort of political exercise, or it comes across that way. maybe a national crime agency doesn't have those restraints on it, so can be more aggressive in saying, this is what's missed, this is what we are hearing from the law enforcement bodies, from the regulators responsible for their particular mandates. These are the challenges they're facing. This is the solution. We've assessed this, we've talked to lots of people, rather than leaving that to NGOs like Transparency International, who do an incredibly good job with a very, very limited budget. But what Transparency International could do with 200 million over 4 years, probably quite a lot. But having and again, it's not, I'm not saying that the NGOs should be the leaders of that. There should be a well-resourced body that draws experts, and maybe they're former RCMP, former prosecutors, former securities regulators, former FinTrack. You have that sort of cross-pollination of expertise and experience that can help develop these solutions, identify what is wrong and how they can be made or how they can be overcome, recognizing the peculiarities of the Canadian system, which are myriad. So I think, and I come back to that, if we're going to do it at a holistic level, then it should be more of a coordination role than an actual, it's going to be dealing with insider trading. I mean, FinTrack, they talk about FinTrack becoming part of this National Crime Agency. FinTrack's responsibility is to promote compliance. Its entire penalty regime is driven towards, it's in their policy statements, is promoting compliance, not punitive. That's completely opposite, in a sense, to what the RCMP's responsibility, or and PPSC. There's a punitive element to that. So again, how do you reconcile those? Well, again, a national agency may be able to, but you can't shove them into one house and say, well, you're both responsible for money laundering in some sense. Let's solve money laundering. Not going to work.
Right. Thanks, Anthony. And I just want to look a quick question and back to you just to follow up. You talk about the courts in Canada and the sort of the burden in Canada may be different than the US and the UK. So how do we need to tackle this issue with the courts in Canada? Any suggestions or insights, and what could be done differently here?
Well, I mean, it's probably the hardest nut to crack, is because there are a series of individual judges will come at things a different way, a different perspective. So one of the issues is depends on the judge you get. Two, any sort of interference or leaning on the court about how you should approach cases, just there's something seems fundamentally wrong with that. So I think we have to recognize that culturally there is, a more defendant-friendly court system in Canada. You could have things like training for judges. You could have more specialized judges responsible for financial crime. I think that would help. A panel of judges. One of the things that struck me when I moved to Canada, having practiced in the UK, so in the UK you have courts. I mean, we have a criminal system and a civil system, obviously, but there are judges who sit on both. They deal with criminal cases and they deal with civil cases. In the UK, yes, it's a bigger bench, but in London alone, the Royal Courts of Justice, you have highly specialized courts for things like technology and construction. And whilst these judges may sit on other cases as well, they are more subject matter experts, and they're the ones doing these highly complicated cases. The big financial crime cases, I'm not talking about small value frauds and the sort of more vanilla criminal activity that involves some financial component. I'm talking about the big ticket items, the stuff that impacts international relations or domestic policy. Having a panel of, or panel of judges, a group of judges, and they have to be in all the major provinces, who are more expert in these, more educated in these, in the components, the challenges associated with financial crime. I think that might be something that doesn't sort of offend the separation of powers, that doesn't look like leaning on courts to say, hey, you're way too friendly to defendants, stop that, stop throwing out these cases on disclosure issues, or I mean, that Brady violations are one of the US, they're pretty hot on those. It's probably a bad example, but I say, more of a training program in financial crime, so you have a pool of judges who are more experienced and more familiar with these issues. That might be one of the solutions.
Thanks for that, Anthony. And Mary, we've been talking a lot about comparisons with the US model. I know you've talked a little bit about sort of the makeup of the FBI in the US. Maybe you could dig in a little bit too, as well as the courts and the prosecutors in the US, and to the extent you can, compare them or contrast them with what's going on here or what we have here in Canada.
Yeah, so in the US, when we talk about prosecutors, remember that we have the umbrella in DC, which is the Department of Justice, which is over all of the regional US attorney's offices throughout all 50 states. So there is the sort of the supervisory parental body that will oversee issues that are occurring across districts. So for instance, we have a Medicare fraud case that we have seen an industry-wide practice by health insurers to basically upcode diagnoses in a particular Medicare managed care space in order to fleece the government, the Medicare program. So it's a great example of how we brought these cases based on where the various, it's industry-wide, so multiple health insurance companies, but throughout the United States, from the Middle District of Florida to the Central District of California to the Western District of New York. And so one of the functions that DOJ does is that they will see these trends and create a sort of repository or a special task force in DOJ to handle these issues. So I think it's important when you think about US prosecutors to know they're not operating in a vacuum within their individual districts. They have that central arm. So from my perspective, every time we file something called a False Claims Act case, where a whistleblower is initiating a lawsuit in a particular district saying that government funds have been misappropriated, we file it, we're required to file it with DOJ. And then we get assigned a DOJ attorney, depending on the size. If they're very small, we wouldn't get a DOJ attorney, but for every case, we're going to have a DOJ supervisory person as well as someone on the ground. And it sort of depends in the local jurisdiction. So it will really depend on the DOJ's desire. They can, except with the Southern District of New York, where they kind of see themselves on parity, for the most part, they see themselves over the regional offices. So I think that's a really important dynamic when you talk about prosecutors, is that they don't operate alone in the US. In terms of how you compare that to a Crown Prosecution Service type phenomenon, I don't understand the system in Canada in terms of how do local prosecutors handle or coordinate with the CPS on things. I don't know, you're going to have to tell me, but I just have the sense that it's not as seamless in that way. So that's just a little bit about my view of the role of prosecutors. I did want to talk just really quickly about something that Jennifer had mentioned and keeps being talked about, which is this issue of compliance and a fear factor that can be created in order to inspire companies to basically adhere to the law and know that there's a threat of prosecution. In the UK, in the wake of the financial crisis, they adopted something called the Senior Manager Certification Regime to say that, you know, no longer can senior managers within financial services institutions and insurance companies just cover their eyes and ears. They actually have an affirmative obligation to go to the regulator. In the United States, we had the Dodd-Frank legislation for Wall Street reform, where we also saw a need. We actually started a whistleblower unit and had protective legislation in the SEC to make sure that people could, the next time Bernie Madoff is about to rear his ugly head, that we would actually listen to the people on the ground reporting. What did Canada do in response to the financial crisis, and who would have led such an effort? And I guess I would finally add back to that, you know, also in the wake of the Enron situation, we created legislation, the Sarbanes-Oxley legislation, which, like the senior managers regime in the UK, requires companies to have internal reporting mechanisms, to allow for anonymous reportings, all of these things that are trying to react to this compliance question of what systems are required to be in place within these organizations to allow that these alerts can happen and be received before we have the next financial crisis. So sorry to turn the tables on you and put a question back, but that was a burning question in my mind.
Thank you for that. And it's always helpful to have that sort of ability to compare and contrast. And Peter, you know, it's sort of, this is an excellent segue into that next, and we've sort of already bled into our next topic of discussion through the audience questions and through just the natural evolution of our discussion. And that is around, you know, some of these gaps that we've been talking about, and those gaps around sentencing, those gaps around, or the contrast we have between the relationship between law enforcement and the Crown, for example, and other structural things that you've talked about in the past, Peter, publicly as well. And I think it'd be very helpful to just for you to dig a little bit deeper into those from your perspective as well.
Yeah, thanks, Peter. And before I get into that, maybe I could just comment on Mary's last remarks with respect to Enron WorldCom, and just to give a little bit of historical background on what happened in Canada, because Canada was tremendously impacted by Enron WorldCom and Arthur Andersen. I mean, Arthur Andersen was a big accounting firm here as well. And because virtually all of corporate Canada, in terms of publicly traded companies, are not only in Toronto, but they're also on the New York Exchange, anything happening in the United States in terms of Dodd-Frank and all of the changes that were occurring there were going to impact Canadian corporations. And a big fear that the Canadian government had at the time was that we would be seen as a fairly lax jurisdiction. And so a decision was made at the highest levels to build up the Canada's enforcement response to market crime. And that gets back to the integrated market enforcement teams, but they were part of a larger federal government response, which included omnibus legislation, as I recall it, that included production orders. I think that's when we first got our production orders. It also included changes to our corporate liability legislation, which had been in the back burner. So a lot of things happened, and a big issue in the seats of power in Ottawa at the time was who should lead the enforcement response for Canada. Should it be a prosecution-led operation, or should it be law enforcement? And we had just had the war crimes example where prosecutors had led the charge against war crimes, and we're talking Second World War war crimes. So that was one model. The other model was our traditional Canadian of investigator or police investigate and prosecutors prosecute, which is what the federal government finally decided to do. So I'll just throw that out as a bit of historical background, which sort of dovetails with what Mary had to say. Whether it's been successful or not, that's a whole other discussion, and I'm not, taking sides on that one at this point. But to get back to what you're talking about, Peter, and I'll just throw out a number of issues that I've spoken about and written about in the past, which make us different from what you see in the United States. Now, I'm not necessarily advocating that we do everything the way it's done in the United States, but I just want to point out some of the problems that law enforcement sees time and time again. And it goes to the issue of, why should we continue doing financial crime investigations because of these various impediments? So what are they? Well, onerous criminal disclosure rules. We do not have statutory disclosure rules in the criminal sense in Canada. We have the Stinchcombe line of cases. Stinchcombe itself is great. I mean, I defended. I did pro bono defense work when I was in private practice. I did paid defense work. I get it. Everybody needs defense, and you need to know the case that you have to meet. And it was terrible if you go back 40 years or so when I started in law. You got virtually nothing. So Stinchcombe in and of itself is great. It's just where it has gone, I would suggest. So we need criminal disclosure rules. Our search warrant process is so time consuming. It's nice to watch the American 48-hour shows. We'll solve the murder in 48 hours. Our police can't even search the crime scene in 48 hours. It's going to take them that long in many cases to get a search warrant. We don't have investigative subpoena power such as you have with the grand jury process in the United States. We now have court-imposed time limits on prosecutions, and the Jordan case, and that has led to police doing things differently. Now all of a sudden you see them arresting people but not charging them for fear that the disclosure requirements will start to kick in, and therefore the time starts to kick in. We don't have a number of things in terms of reporting legislation. We don't have universal cash reporting in the money laundering context. The United States does. So there are lots of entities that are prone to money laundering that don't have to report in this country. Casinos have to report. Car dealerships don't have to report. Antique or auction houses don't have to report. Boat dealers don't have to report. We don't have universal cash reporting. Another one that really bothers police officers is lying to a police officer. There's no offense in this country. Yes, there's obstruction, but there's a high onus on obstruction. Whereas you just have to look at what happens if you lie to a federal agent in the United States. That's used time and time again as leverage to get a cooperating witness. Sentencing guidelines. We're adamantly opposed, it seems, in this country to minimum sentencing thresholds. But the net result, and I was Deputy Commissioner of Corrections for 4 years after leaving the RCMP at Federal Corrections, and the reality is, if you're a non-violent offender, you don't go to jail for very long at all. You're going to be out. So, the police prosecutors can work 5-6 years putting a case together, as we've seen in the fraud world, and an individual essentially ends up in house arrest. So there is a reality that sets in, and people say, why? So I could go on, and I haven't even touched on the different, approach that prosecutors and police take, but that's sort of been spoken to. And I also have not talked to, well, let me just throw in one other thing, and that's lawyers. And being a lawyer, I quite appreciate the need for solicitor-client privilege. That's not in debate. But Canada does not require lawyers to report on any level to a third-party body or FinTrack. I mean, that was tossed in 2015. And Mr. Justice Cromwell, who wrote the majority decision in 2015, essentially said, federal government, there may be a way for you to do this. But we're 6 years down the road and we still don't have a fix. We are still, offending the FATF guideline recommendations and so forth. So I'll stop there. There's a whole plethora, obviously, of issues that I think we could fix, if we had that political and bureaucratic will. There's a lot of politicians that actually want to fix these things. But then all of a sudden, it gets into the bureaucracy and changing priorities, and I get it. And nothing seems to happen over time. I'll stop there.
No, thank you very much, Peter. That's an excellent perspective. And Jennifer, I mean, it's not much for me to set up here. I think that there's a lot to unpack with these previous comments, and I think we'd benefit from your perspective on this topic as well.
I'm going to start with the statement that I mentioned before, which is that we have to get out of the idea that the criminal law can solve everything, and that only through criminal enforcement can we be perceived to take things seriously. I just want to put it on the table because I don't know who's sitting in the audience. Even in what we would call street crime, we expect and we depend on the fact that not every violation of a criminal prohibition is investigated. Not all of those investigations result in charges. Not all charges result in an actual prosecution being started. And even when you get to that point, most prosecutions settle. So, and the Supreme Court has said over and over and over again, we are in a system where we must accept that settlements and other resolutions of these situations are important. So I put that as my starting point, because we are now talking about the very pointy end of an enforcement strategy that cannot possibly be the only part of enforcement. And many people say, oh, that's so ugly, all those negotiated settlements, and we don't know what's going on. And we have to be pragmatic here. It's not possible to do that. So you have to set this as saying it's important to have enforcement, and it's important that enforcement serves the purposes that are identified. I'm going to get to that in a second, but we cannot imagine that all cases end up like this. So then that really puts a lot of emphasis on which cases. What's your decision-making process for selecting cases that are the right kind of cases to bring forward for a contested prosecution? Because everyone, the Hail Mary, everyone thinks that contested prosecution and a conviction following a contested prosecution is sort of the alpha result. And yet, that's a unicorn outcome in a lot of cases, even more so in this area. The fact of the matter is that under the new amended criminal code, under the new rules that were added to the criminal code for corporate criminal liability, we have, I think now, 2 prosecutions that actually went to trial and there was a conviction that issued, and one is not an economic crime, one is in competition. And in the competition case, they had wiretap as evidence from the witnesses, and the witnesses had pled guilty. So there was a huge amount of evidence on the table. What happens is there are negotiated settlements. They're either plea deals or they're alternate arrangements. And in fact, in competition law, we've seen some alternate arrangements emerge because competition offenses are not eligible for mediation agreements. So all this talk about, kind of how do we structure the police services? How do we deal with prosecutors is very much in a mindset of saying, yes, about the cases that we actually have to bring forward. And of course, you have to investigate more than you're going to ultimately decide, but that you're ultimately going to bring forward. And you do have to learn things from those investigations about what to look for, what are the signs, that kind of thing. That's important, right? But the other thing that I think needs to be really put on the table, Anthony talked about prosecutors being extremely cautious in this country, and with reason, is, the public and sort of the political masters, even though we're supposed to have complete separation from political influence in the prosecution service, we have to be careful not to tap on prosecutors every time they, quote unquote, lose a case. Contested prosecutions do not always result in a conviction. And the obligation of a prosecutor is not to obtain a conviction, but to see that justice is done. And so if prosecutors are basically sort of thrashed every time they don't get the conviction, they become very gun shy, right? And then they're going to prefer a settlement then rather than even going the distance and getting perhaps the judicial decision that allows the law to evolve. Now, I'm not saying that prosecutors set out to lose. Most of these are very sharp litigators. They want to succeed, but I think we have to set our expectations a little bit differently when we're talking about this kind of enforcement area. I want to come back to 2 other things. First is about sentencing guidelines. It's true in Canada we are allergic to the notion of an established sort of set of criteria that set out. It's not so much minimum penalties as because the U.S. system is not just minimum penalties. It's a system which tells you kind of how to arrive at an appropriate penalty. And in economic crime, a lot of it is about what are the factors that will push a number up or down in terms of a fine. I'm grossly simplifying. Mary, please come in and correct me whenever you want. But I think what's important is that the other component of that, which makes the US system work, is that prosecutors basically have certainty because of the respondeat superior rule that they will get the corporation. So you can either talk to us and negotiate, or we'll go to the judge and get the conviction. And then you're in a much worse position. So that allows also, it structures the conversation differently. And then the company is motivated to provide the information to say, look, there's all these things we want to tell you about, all these things we've done. In Canada, we don't have that mechanism by which we incentivize. We've tried the remediation agreement regime, which so far we still don't know, does it work? You need to incentivize companies to come forward with the information because the primary challenge is getting the evidence. And if you combine with that, the stakes are so high in contested prosecutions, we don't have the resources, and we cannot imagine that we will ever have a court system that's so efficient that we could just prosecute every crime. It just isn't going to happen. So let's talk about strategies that help us get to resolutions otherwise. And that's where I think the agency comes back, whether it's a coordinating agency or an enforcement agency, like I imagine, where you might, develop some in-house expertise specific to a certain area. This is where you can build that momentum. Final thing I want to talk about is judicial education, because Anthony talked about it a little bit, is that I do think in Canada there is a gap in judicial training. at least among the generalist judges. There are some specialized judges, there's the commercialist in Toronto and so on, but they're not necessarily sitting on the corporate benches, or it's just happenstance, right? You have some who are specialized in competition, who know a little bit more. Judicial training that would allow judges to be able to independently make some sort of assessment of what's being presented to them, because 95% of the time it's a guilty plea with an agreed submission on sentence. And yes, there's deference to the parties, but if you don't actually know how those things are put together and what does a compliance program really look like, what are the kinds of things that you should be required, then how do they really know? And how can they really have, input on the situation? So far, it's a lot of analogies through what works with human beings. That's not good enough, I would say. Anyway, I'll stop there.
No, thank you very much for that, Jennifer, and some valuable insights there as well. We've covered a lot of ground, but we are getting a lot of questions from the group chat. Now, I want to take a little bit of time to see if we can cover off some of these questions. And one of the questions that we got, Peter, is specifically directed towards yourself, but I found it an interesting sort of take on this discussion as well. A little bit unrelated, but still an interesting take. In terms of specifically dealing with corruption in sport and the significant changes in what we've seen in other aspects of what we're finding focus on in Canada, whether it be corruption, financial crime, human trafficking, but sport corruption is also a top of mind, or a very large or growing problem as well. And I don't know if you have a comment, or you can shed any light in terms of the Canadian authorities being chased internationally to try to move this up in terms of the area of priority when it sort of deals with money laundering, fraud, and corruption, and all the things we're sort of talking about today.
Yeah, thanks a lot, Peter. Well, I think a decade or so ago, we would have dismissed any comment of corruption in sports. It would have been really, but it is a very serious issue internationally, and it should be to every country that competes internationally. And there have been flagrant examples of corruption in sports. So it's a topic of discussion internationally. Certainly Transparency International people would be quite familiar with that discussion. We have to be alive to it. We are about to launch a center at the university in ICLR, an anti-corruption center. It'll be called the Vancouver Anti-Corruption Institute, and sports corruption is one of the areas that we considered with our financial advisory committee, with our corruption advisory committee, because it is high profile and it does concern the international community. Now, in terms of the tools to fight sports corruption, it's no different than any other corruption, really. If you have people that are being bribed, they're being bribed, whether it occurs in this country or elsewhere. So all of our existing legislation should be able to adapt to corruption in various different walks of life. But I think it also gets back to the issues that Jennifer has raised, and that is that it's not, and it can't be just about enforcement. If we're going to change the specter of corruption in sports, that's not going to come from the courts. That's going to come from international bodies that realize you don't want sports to be corrupt. It should be a level playing field. So I think really the solutions to corruption in sports, if we ever get to a solution, will come from something other than enforcement. Having said that, agencies have to be aware of the problem and be alive to it, and certainly not dismissive. And I would be surprised if they are dismissive at this point. But again, you require whistleblowers, don't you, Mary, in many of these situations, coming forward and knowing where to come forward. I'll stop there.
Sure. Thanks. What I'd like to do, though, is I'm going to bring us back now a little bit, and I've got another excellent question from the Q&A chat, and that is dealing with, and I mean, it goes back to, I mean, Jennifer, you may have to put on your pessimist hat again, but but I'm going to start with Anthony, though, and so, but looking at this, and then I'm going to, you know, well, I mean, this is something for the entire panel to sort of address as well. But so, Anthony, there's a level of frustration in Canada. You know, when I saw the announcement for a new federal financial crime agency, I was not excited. I was, you know, almost depressed that, oh no, how many years is it going to take for them to get this agency off the ground? And are we just sort of delaying our focus on financial crime for another 3 to 5 years while we get this set up? And so I just wonder whether or not, is there a desire, is there a political will in Canada? Because it's not just this, it's the enforcement of our anti-money laundering legislation. It's the anti-corruption legislation. It's the track record of prosecutions of any white-collar crime. And is there the desire in Canada by the federal government to deal with economic crime issues?
I think, I mean, the history would suggest not really. But what I would say about this announcement is it's an opportunity. Political will ebbs and flows. And it shifts from one priority to another as well. What is, you know, what resonates at one time, or what is a popular issue at one time, may have some political will, but that will shift to some other priority. So one thing I would say about this announcement, and you know, I understand the sort of the pessimism and the slight air of, you know, this is just another thing that won't really go anywhere, or it'll be a bit of money thrown that doesn't really go anywhere, is the opportunity should be taken whilst it's in there. If this money really has been allocated, $200 million, then I can see $200 million is enough to do something significant, as long as it is thoughtful and focused. And I've said it multiple times today. I think what is missing is a permanent strategic vision. And that is, if, you know, maybe again, this financial crime agency has a role, it's in that consistent vision. It may shift in terms of priorities, or in recognizing what those priorities are at a given point in time. Once you fix one, you move on to the next. There was obviously issues that cross all types of economic crime. But that there is, you know, say, some sign of political will. We've had the Cullen inquiry in BC. To my mind, it's astonishing to me that we haven't had a federal one, given how, you know, significant an issue money laundering is in Canada. Why? Like, why have we not got it? To me, I think that the Cullen inquiry has actually been and will prove relatively successful and valuable. But he's got to be very careful, Justice Cullen, about overreaching his provincial boundaries, his terms of reference. So, you know, that it's only going to have be able to look at a very limited subset of issues. But, you know, having a federal commission of inquiry, again, you know, national crime agencies could be someone bringing that to the table and saying, this is important, we need this issue canvassed in a public forum, you know, like the Charbonneau Commission, you know, touching on some of the findings of Commissioner Cullen at a federal level. It's just one example. We've talked about all sorts of other, Peter mentioned a whole bunch, Stinchcombe, all of, you know, the issues with you can't change Stinchcombe unless you have a statutory disclosure at a very granular level. Jordan, again, it's a decision of the court, but there are exceptions to it. It's created a culture of conservatism about, you know, bringing charges or delaying the bringing of charges that have lengthened the investigative period in a case. But it doesn't have to. That's not what the decision necessarily finds. It creates a hurdle, a presumption that they're time barred after 3 years. But again, you know, education of judges. So this is a role that, and again, a national crime agency can play a role in picking out what can be done, what would be a useful priority, and engaging at a political level with, you know, Judicial Council, you know, judges, bringing other stakeholders, again, corporate world, on compliance enhancement, what it would take, what's missing, why isn't there more of a culture of compliance, and again, setting agenda and pushing a more consistent focus on economic crime. Otherwise, Peter, you're absolutely right. This is going to come and go, and it's not going to go anywhere. Or if the $200 million is spent, as Jennifer said, not a lot of transparency often around it. Where the hell does it go? There was 50 million allocated for anti-money laundering with the RCMP, the back end of 2020. How was that spent? Don't know. Has it been spent? Don't know. But it's not, it's not terribly edifying not to understand where this money is going and why it's going to, sort of particular announcements, or what is the substance of the announcement behind it. Case in point is this National Crime Agency. What is it? It's so abstract in how it's being framed. It's tied to housing. I can draw the inference that money laundering and the effect on house pricing is part of what's driving this. That's a very topical issue. Okay, but is that the entirety? Again, there's no, it comes back to my point about lack of coordination, lack of consistency, which is one of the things I think the National Crime Agency should itself solve, rather than being responsible for the actual prosecutions and the actual substantive investigations.
Thanks very much, Anthony. And Peter, it would be good to get your perspective on this. I mean, just in my short existence, I've seen many iterations within law enforcement in Canada trying to tackle these complex and difficult issues, from the IPOCs and the IMETs and the anti-corruption enforcement team and the complex investigations team and a myriad I'm likely leaving out as well. Is there the political will in Canada? I've said it before, we seem to have an unending capacity in Canada to tolerate economic crime. And I'm just talking about the electorate. It's rarely an election issue. I don't think an election has ever turned on it. So I'd like to hear your perspective on this.
Yeah, thanks, Peter. I really don't put this necessarily at the feet of politicians or bureaucrats. You're 100% right. We're Canadians, and there's a certain Canadian way about us. But the other thing is priorities in government, and I'm the first to accept that everybody wants, whether it's education at the provincial level, whether it's health at the federal, provincial level. We've got priorities in our lives, and this is not the top priority for Canadians. My concern, though, is that if you just ignore it, it's only going to get worse. And that leads back to that tipping point argument. When I did I've said it many times, I'm not a political animal. I don't belong to a political party, but I was very impressed by Attorney General Eby in our province, who decided to deal with, as best he could, money laundering at the provincial level. And when I did my dirty money reports, I was quite pleased by the support that I received there. But I would also say the same thing about our public safety minister federally at the time, Bill Blair. And I've said this publicly. He's a politician with a long background in policing and wants to make a difference. So, it's easy for us to say, oh, it's all about the politicians. But there are some bigger issues, I suppose. We operate on a five-year strategic plan in this country, so to speak, because elections are every 5 years. So governments don't stay forever. Politicians don't stay forever, which then makes the bureaucracy so important. And the bureaucracy has to want to make change as well. And that's both at the federal level and at the provincial level. The issue that you raise about enforcement agencies and what's the best way of dealing with it. I mean, for the longest time, the view was that you want specialist agencies within, let's say, the RCMP, provincial police, and so forth, the integrated teams. They would be specialists in proceeds of crime. They would bring together legal assistants, accounting assistants. You'd have people dedicated to a particular business line. That has sort of evolved into a different concept now, where everybody is sort of working in this field of organized crime. And unfortunately, a lot of the specialists have sort of disappeared because of that. So there are a whole lot of things packaged together, and I could probably go on ad nauseum on this, but I hope that starts to answer your question anyway.
No, I appreciate that. Yeah, and I want to hear Mary's perspective as well, because you talk about, you know, we talk about, well, we're Canadians and we're just so good. We're just we don't worry about this economic crime stuff, and it's not really that bad. And can we just get on with hockey and beer? And so I wouldn't, you know, the U.S. though, this elections do turn on it. It is big news in the U.S. and these prosecutions are high profile and political careers are made on this topic. So what's different?
Yeah, I don't want to say that. I think we are reactive. And some of our biggest changes come as a result of the role of the press and investigative journalists. So to give one example in this area, the role that the International Consortium of Investigative Journalists has played in their collaborations, where they basically turned on its head this idea of press jealously hoarding stories to collaborating with massive data in conjunction with massive data dumps coming from leakers. That has really changed the dynamic. So if you're talking about money laundering in particular, you know, Senator Klobuchar has been trying for years to get an Anti-Money Laundering Act update passed, but it was really the FinCEN files investigation where an insider within FinCEN, a woman named Natalie Edwards, leaked thousands of suspicious activity reports that really turned up the heat. So it's those sorts of external forces that have helped us, in particular, in the beginning of this year, really taking the lead from the UK and their ultimate beneficial owners registry and things. We actually passed a new Anti-Money Laundering Act. We hadn't done that since 9/11 and the pressures with terrorist finance. So one piece of that is actually rewarding whistleblowers, much like the SEC does, for information about violations of the Bank Secrecy Act. So I think it really just depends. Where the political will comes from what what the journalists tell us are points of embarrassment that we need to address. Also comes obviously from presidential priorities. So you look at Biden's need to finance infrastructure bills and other of his pet projects and important projects. He needs to invigorate tax enforcement to bridge the tax gap that he could pay for a lot of things if we could get people to actually pay the tax that they're owed. So, you know, there are wills come from that as well. So I think the one place where I'm most keen to discuss sort of American priorities is, for better or worse, we're really good at going after foreign bribery and corruption. People will say we look at foreign corporations more than our own corporations, although we've also gone after Walmart and other folks. So I think there's been consistently across presidential administration a desire to be a leader in the space of going after government corruption as a way of noticing that it corrupts the market forces. But I think most importantly, when you talk about any of these discussions and the Biden administration and the new Attorney General, corporate crime is only a reality that it will ever be addressed if we have individual accountability. So we had the Yates memo under the Obama administration coming out of too big to fail, too big to jail, right? So again, that's us being reactive to the financial crisis, but saying we need to hold individuals accountable, because if we don't, all of these deferred prosecution agreements, what they mean is that you get to conveniently settle this without having a criminal exposure, and you can rebrand yourself and come up with a new name. But it's the individuals who, if they're not held accountable, keep moving from organizations to organizations and perpetuating this. So I'm pleased to say that in a recent speech, one of the heads at the Attorney General's office from Merrick Garland basically pointed out again, we need, these are the three prongs. We need to deal with individual accountability. We need to deal with corporate recidivism. And we need to go back to installing corporate monitors in place. So again, I guess my theme is that we don't have some grand will. We're incredibly reactive to the outside forces. And thank God, please, may we have a robust free press that helps keep and hold all of us accountable.
Thank you. Thank you very much, Mary. You're being extraordinarily generous and kind to us. Anthony, you're going to chime in for 1 minute, and I do want to spend some time with Jennifer getting her reactions as well.
Yeah, I just want to, I mean, Mary's absolutely right. So enforcement is one of those things that's going to get this more in the public domain. And I do think, it hasn't been of huge interest or as much interest in Canada, and the tolerance for economic crime is probably a bit high. But the more we have enforcement, the more I think it'll get column inches and it'll be more in the public consciousness. But the point I wanted to make is we don't really have an activist body responsible for economic crime. We're very quiet at the sort of enforcement bodies, investigative bodies, and I understand why they don't want to step into the sort of the public domain. But again, that is something that a national agency that sits above as an sort of coordination and policy role might solve and might help to get more column inches, can be more public in issues, in tackling this. So I think that in turn would help drive the public consciousness. David Green in the UK was very vocal about things like failure to prevent offences, because of the problem with corporate criminal liability standards, which is a problem here as well. And he was a real driver. I don't see that ever happening in Canada, but National Crime Agency and the lead of it might be the solution there. So I'll turn over to Jennifer now.
Thanks, Anthony. And so Jennifer, just looking at time, you're going to get the last word of the day, and then I'll sort of summarize our comments and turn it back over to Joe.
Well, thank you. I guess I get the privilege of not being rebutted after I finish. I wanted to follow up on Anthony's. He's got a particular idea of what a national agency should look like, and I think it's a very interesting idea. It's not the one that I had been thinking of, but I do think that one of the things that is useful about that model is the policy making function. And I would just like, for those of us who have long enough memories, the Competition Bureau, which is an independent investigation agency and does, is a voice for competition policy in Canada. They, just before the 2009 amendments, there was a competition policy advisory panel that looked into, how we could address issues of innovation and competitiveness of the Canadian economy. And that's where a lot of the, support for these amendments, even though many of them had been percolating for many years, that was where the push came from. But one of the things that was not taken up that this panel suggested was that the Bureau needed to be an independent agency that could advocate and study, competition policy and put forward proposals. And I think that maybe it's time for us to reconsider, I think in competition they need it, but also in the context of financial crime enforcement, for the reasons that have been, very clearly stated by others, which is that you need a voice, and it can't be those who conduct the investigations or the prosecution service who will never comment, right? You need a voice that says, look, we're watching the trends, we're gathering the information, and we observe now over the past 5-year period that this rule is not working. And we suggest the following tweak. Now, politicians have to take it up. We know that legislative agendas get crowded and, things don't happen. But I think the point is that it allows the expression has been overused, but kind of a sober second thought or a long view of these things, so that when the time is right, when some Minister of Industry says, look, is there anything we could do on financial crime? Hey, yes, we've got a bunch of things that we've been thinking about. And so these are thoughtful proposals that are based on evidence, that are based on information. I think that is a big part of the problem, is that it's always reaction mode. So like this thing that dropped out of the sky where it's like, yeah, financial crimes agency. well, where did that come from? And where's the reflection behind that? And what, instead of saying, there's actually an agency or an organization or an umbrella group or whatever you want to call it, that its primary mandate is to think about how we can improve the system. And periodically, we're going to take them up on their ideas, or we're going to at least test those ideas and see whether they're workable and what we can do. I think that would already be a big step in the right direction. The other thing that I hope everyone is getting out of this conversation is that regardless of what we choose, whether it's an agency or whether it's, trying to improve the status quo, coordination and cooperation are essential. So the siloed approach is not going to work. And agencies, even if they have specific mandates, have to talk to each other. Enforcement agencies, provincial prosecutors and federal prosecutors, there has to be a spirit of cooperation, whether that's achieved through memoranda of understanding that actually sort of specifically articulate how that cooperation is going to be, or whether there can be a more general approach. I think without that will, much more than political will, it's the willingness of those who have a stake in enforcement, but also have a stake in the system working. So I include the defense bar in that, and private, the compliance bar. People have to be willing to cooperate and make it work, because everyone should have an interest in eradicating the worst forms of these behaviors. And if I'm going to make my parting shot with what I started with, is that why do we care about these crimes? What is it that bothers us about them? What is it that bothers us about these behaviors? It's not just about the money. And I think that when we talk about what attracts attention when we get these investigative journalism things going, is that people are like, wow, this is a lot worse than I thought. People get killed, people get hurt, lives are destroyed. So maybe we need to turn the conversation a little bit in that regard. I'll turn it over to you, Peter.
Thank you much, Jennifer. And we want to finish on time. And so in order to do that, that had to be the last question posed to the panel. So I appreciate that. This has been a phenomenal panel. I mean, and it's been a phenomenal audience too, because some fantastic questions that came through. We did not get to them all, so I apologize for that. I do believe that with the upcoming release of the Cullen inquiry here in BC, there is a very robust need for a follow-up to this call, maybe early in the new year, as everybody gets to do that, and to tackle some of the other questions that have come through and the other topics that have been raised as well. I mean, this is a discussion that could go on for days, not just hours. And so you've made me work for my coffee this morning. It wasn't even free coffee. I had to supply my own coffee. But I look forward to the next session like this, whether I'm moderating or just in the audience listening, because I've learned a great deal today from Mary, from Jennifer, from Peter, and from Anthony, and from the questions that came from the audience as well. So, Joe, without further ado, one last thanks to this eminent panel. Back over to you.
Thanks very much, Peter. I'll finish up with a couple of comments here. I've just been so impressed by the panel and your moderation, Peter. It's gone really well. I'm just so pleased that the Anti-Corruption Law Program established this panel and the event. We'd like to convey our special thanks, of course, to Dr. Carol Yao at the Center for Business Law, Sonia Lee Trottier, who ran the webinar so effectively, and the panel, really good panel. Just everybody brought interesting perspectives to this whole issue. And it's quite clear that this conversation needs to continue, and that we need to contribute. The Anti-Corruption Law Program looks forward to contributing in the future to this kind of discussion. And just to let you know, the participants, to let you know that we have plans for further events in the coming months. There will be a special TI Canada event on December 9th, which is International Anti-Corruption Day. And we will follow that with a series of webinars, one of which, interestingly, will include a session on corruption in sport. Joe Weiler has particular interest in this field and expertise. So I would ask everyone to monitor our website at the Allard School, watch your inbox, and check our LinkedIn page. We also have a section on the Anti-Corruption Law Program. So once again, sincere thanks to everyone. Peter, you did a great job, and all the panelists, thanks again. Over to you, Sonia Lee.
I think that's it.
I guess we're signing off now.
Yeah, we're signing off. Yeah, good.
Thanks, everybody.
Thanks very much.
Thank you. Bye.
Bye.